A Swedish startup with no courtroom history and no legacy client base just hit a $5.55 billion valuation and launched a global ad campaign starring Jude Law. That combination should not make sense. Legal technology has existed for decades. Document management, e-discovery, contract databases, the infrastructure has been there. Yet the industry remained invisible to anyone outside a law firm's IT procurement list. No brand broke through. No company made legal software feel like something worth paying attention to. Legora changed that calculus. The Stockholm-based company builds AI tools designed to automate the core production layer of legal work: case law research, contract review, due diligence, document analysis. Tasks that once consumed entire associate classes are now being processed at scale by systems that don't bill by the hour. But the product alone doesn't explain a $5.55 billion valuation. Plenty of capable legal AI tools exist. What separates Legora's trajectory is something structural, a deliberate decision to build brand architecture that could carry enterprise trust before the product had the track record to earn it independently. The Jude Law campaign, taglined "Law just got more attractive," is not a vanity move. It signals a repositioning of legal technology from cold B2B infrastructure into something culturally legible, aspirational, visible, and designed to become the default name in a market that has never had one. This is not a standard SaaS growth story. It is a scaffolding strategy. But to understand why that strategy worked, you have to go back to where Legora started and what problem it was actually trying to solve. Stockholm is not a legal technology capital. The profession's institutional gravity sits in London, New York, and a handful of other cities, where centuries of case law, client relationships, and billable hour culture have calcified into something close to permanent. Building from Sweden meant building without proximity to the market. No natural referral network, no inherited credibility, just a product that had to earn its way into rooms where trust is the primary currency. The structural resistance Legora faced was not incidental. The legal profession carries a specific set of constraints that make technology adoption genuinely difficult, not just culturally, but professionally. Privilege, confidentiality obligations, and liability exposure mean that every tool a lawyer adopts becomes a risk surface. The profession has historically equated manual effort with professional credibility. Doing the work yourself was not inefficiency, it was proof of competence. That is the wall Legora had to navigate, not a feature gap, not a pricing problem, an identity problem. The insight that shaped Legora's early positioning was precise. The barrier to adoption was not capability, it was professional self-concept. Lawyers were not resisting AI because it couldn't perform. They were resisting it because adopting it felt like a concession about what their expertise was worth. Legora's response was to reframe the value proposition entirely. The platform was not positioned as a replacement for legal judgment. It was positioned as infrastructure that elevates the lawyer, shifting their value from document production toward strategic interpretation, risk translation, and client alignment. So, how do you sell change to an industry that treats change as risk? Legora's answer was counterintuitive, and it started with a golfer. The golfer came first. Before Jude Law, before the global campaign, Legora attached its name to Ludvig Åberg, a rising professional golfer with no obvious connection to legal software. That choice was not random. Golf indexes heavily toward the demographic Legora needed to reach: senior partners, general counsel, FTSE 100 executives. The sponsorship was a signal, not a stunt. It said that Legora intended to build brand equity through cultural proximity rather than conference booths and procurement white papers. Then came the inflection point. The Jude Law campaign, taglined "Law just got more attractive," landed as something the legal technology sector had never produced before: a category claim, not a product claim. It did not argue that Legora's features were superior. It argued that Legora represented what modern law looks like. The strategic logic is precise. Enterprise software adoption in conservative industries runs on social proof. Corporate counsel and FTSE 100 legal teams carry significant reputational exposure in every vendor decision they make. When Legora arrives in a sales conversation already recognized, already culturally legible, the trust-building phase compresses. The first call is not an introduction, it is a confirmation. Harvey understood the same mechanism. Gabriel Macht, the actor who played Harvey Specter, became a brand ambassador. A partnership with Fulham FC followed, two companies converging independently on the same strategic conclusion. In legal AI, brand is not marketing spend, it is sales infrastructure. Legora was not selling software to enterprises, it was selling legitimacy. The campaign was the delivery mechanism. But a campaign generates awareness. It cannot generate a moat. Awareness opens doors. What keeps them open is something harder to replicate. Legora's moat is not the AI model itself. Models can be copied, fine-tuned, or surpassed. What cannot be easily dismantled is the scaffolding built around the model, the layered combination of brand authority, professional identity alignment, and enterprise partnership depth that makes switching genuinely costly. The Bracewell LLP partnership illustrates the mechanism precisely. Bracewell did not license software, it announced a strategic partnership, language that signals something structurally different. When a law firm frames a vendor relationship around innovation and client service rather than cost reduction, it has embedded that vendor into its operational and reputational identity. The firm is no longer just using a tool, it is publicly aligned with what that tool represents. That distinction matters because it activates a compounding loop. A high-profile firm partnership generates case studies. Case studies generate enterprise credibility. Enterprise credibility accelerates the next partnership. Brand and product reinforce each other in a cycle that becomes progressively harder for a competitor to interrupt. Expert commentary from Simon Marshall makes the valuation logic explicit. High-profile branding builds broad market recognition, and that recognition justifies premium pricing and enterprise trust before the product's track record can do it independently. The identity lock-in operates on the same principle. Firms adopting Legora are not simply purchasing software, they are signaling a professional posture to clients, to recruits, to the market. Legora's stated ambition is category verb status, the kind of brand recognition that turns a product name into the default term for an entire behavior. The scaffolding is architectural. It was not accidental. Once the scaffolding is in place, the question becomes, how fast can you build on top of it? And what does dominance actually look like in a market this early? The $5.55 billion valuation is not a revenue multiple. It is a probability bet. Investors pricing the likelihood that Legora becomes the default legal AI platform for enterprise firms globally before that category fully consolidates. That number did not arrive gradually. In October 2025, Legora raised $150 million at a $1.8 billion valuation. 5 months later, Excel led a $550 million Series D at $5.55 billion, a tripling of valuation in a single funding window, backed by 14 investors from Benchmark to Salesforce Ventures. The speed of that revaluation is the actual data point. Early-stage category valuations are not assessments of current output. They are assessments of position. And Legora's position is unusually concentrated. The FTSE 100 targeting strategy identifies corporate counsel at large public companies as the primary adoption vector, not because they are the easiest clients to win, but because they are the most consequential. A single reference account at a major public company compresses the sales cycle for every firm watching that decision. The competitive dynamic confirms the stakes. Harvey's parallel investments in brand infrastructure, celebrity ambassadors, sports partnerships, cultural visibility are not coincidental. Harvey confirmed a $200 million raise at an $11 billion valuation just 15 days after Legora's Series D closed. Two companies, operating independently, converging on identical strategic logic. In legal AI, brand is not marketing spend, it is sales infrastructure. Together, they represent more than $16 billion in combined enterprise value, in a market that barely had a name 3 years ago. The race is to become the assumed choice before the market has fully decided there is a choice to make. Expert analysis adds a necessary constraint. Brand scaffolding accelerates trust, but enterprise clients will demand more than recognition. Clear product development roadmaps, enforceable confidentiality protections, and privilege-safe architecture are non-negotiable requirements at this level. The brand opens the door. The infrastructure has to hold the weight. The compounding structure underneath all of this is precise. As Legora's brand matures, acquisition costs decrease while switching costs for existing clients increase. That asymmetry is the actual moat. So what's the transferable lesson here? And does this framework only work inside legal tech, or does it apply somewhere broader? The framework Legora has built has a name now. Call it brand scaffolding, the deliberate construction of cultural legitimacy ahead of product maturity, designed to compress adoption cycles in markets where trust is the primary barrier to entry. It operates on 3 layers. First, identity alignment. Reframe the technology not as a threat to professional expertise, but as its elevation. The lawyer does not become redundant. The lawyer becomes the strategic interpreter that the system cannot replace. Second, cultural visibility. Invest in brand signals that reach decision-makers outside the procurement funnel, before the sales conversation begins. Third, partnership depth. Convert early adopters into structural partners, not transactional customers. When a firm's reputation becomes publicly linked to your platform, the switching cost is no longer financial. It is reputational. The constraint that makes this framework work is also the constraint that limits it. Brand scaffolding only functions in pre-consolidated markets. Once a dominant player holds genuine product moats, deep integrations, proprietary data, enforceable compliance architecture, cultural cachet alone cannot displace them. The window is early, and it closes. The legal profession is mid-transition. Value is shifting from manual production of legal knowledge towards strategic interpretation and client alignment. Legora's positioning tracks that shift directly. The same logic applies to healthcare AI, financial advisory, and any regulated professional services market where identity and liability intersect. But expert voices have been clear. Enterprise clients will require product development and enforceable protections around privilege and confidentiality to match the brand investment. The scaffolding is up. The question is whether Legora builds the building fast enough, or whether the structure stands long enough for someone else to move in.
Learn the next winning strategy.